Welcome to this video series on addressing the dispute resolution challenges of Japanese companies doing business in ASEAN. This series is brought to you by the ASEAN Japan Center, the Singapore International Arbitration Center, and the Singapore International Mediation Center. In this episode, we will be sharing practical tips to help Japanese companies overcome some of the challenges of doing business overseas and in ASEAN in particular. I am Michelle Sonnen, and I am the head of Northeast Asia at SIAC. I am joined by three attorneys experienced in working with Japanese companies conducting trade and investment in ASEAN. Mr. Yoshihiro Takatori, FCIArb in Japan, international mediator and arbitrator. Ms. Vu T. Quay, partner and chairwoman at Rajah and Tann LCT in Vietnam. And Ms. Natalie Yap, counsel at Nishimura and Asahi in Tokyo. Now, we know that foreign investors often fear that they're going to be treated unfairly by local authorities or that unexpected changes in local laws will have a detrimental impact on their investments or projects. For Japanese companies investing in ASEAN, what potential issues should they be aware of? And are there steps that they can take to address or mitigate these issues?
So organizations like the Japanese Embassy, JETRO, or JCCI, they may act as an intermediary between their members and local authorities to safeguard the legal rights and interests of the investors and promote the legitimate business community. So they may also serve official letters on the government or competent authorities or arrange meetings in order to further help them to further consider the reference to main international standards of investment, such as fair and equitable treatment, FET, or full protection security, FPS, or national treatment NT, and most favorable nation treatment MFN, which may be found in most of the free trade agreement FTA to which Vietnam is a signatory. So in practice, we do have seen that the JCCI and Eurochamp in Vietnam are very active foreign chambers that they helping their members to seeking for other consideration from the government during the claiming of the members relating to the tax and the custom issues in Vietnam. So, however, it is worth noting that not all of the case that the foreign diplomatic and the association and the chambers approach is workable for resolving the dispute. So the administration proceeding in Vietnam, like the Vietnamese court, is quite comprehensive and time-consuming. The Japanese investors may also consider to refer the potential dispute to the Vietnam International Commercial Mediation Center, VICMC, for their supporting to resolve the issues amicably.
In my experience, I think it's really important that the parties work closely with local counsel to consider very carefully at the contract stage any eventualities which may result in additional costs or in delays, which may disrupt the performance and the enforcement of contractual obligations. And what those eventualities are will depend on the context and the nature of the contract. For example, there may be legislation which comes up during the life of the contract, which dramatically increases a new tax or which newly implements a tax, or which requires additional import or export procedures which could disrupt the supply chain, for example. So it's important to carry out a thorough risk assessment at the outset so that the risks can be agreed on and allocated, for example, through indemnities or price adjustment provisions, or pay when paid process, or time extension mechanisms.
Let's move on to the next question. Oftentimes when companies are faced with unexpected changes to local laws, or when they encounter setbacks due to regulatory obstacles, dispute mechanisms can be used to help them find a way forward. Can you elaborate on how Japanese companies use international arbitration and international mediation to resolve these kinds of issues with business partners?
The Japanese corporations, they have three options, legally speaking. First one is the fighting at the local courts and utilizing the local laws and the regulations, but that could be sometimes tough. And then second option is the arbitration and the mediation hopefully in third countries, like in Singapore, and including online practice under the current stage, and also for to be governed by the foreign governing law on the substantive law and the procedural law. That could be useful for keeping the neutrality and fairness. And then third option is the so-called investment treaty arbitration and the mediation, and utilizing the ICSID or something such public organization. And so for those two and the three options, kind of arbitration and mediation, and sometimes can be combined together as the ARB-med-ARB type of practice.
I think it's very important, as Takatori Sensei says, for the parties to understand how their dispute resolution procedures are going to work at the contract stage. And in connection with that, they need to understand that mediation and arbitration operate very differently. With mediation, parties can explore options which are completely outside four corners of the contract, and they can focus on the commercial objectives of the agreement. Parties can consider, with international mediation, what protocols and procedures are available. For example, the Japan International Mediation Center and the Singapore International Mediation Center offer a joint mediation protocol, which may be of interest to parties doing business with the Japanese element. With regards to international arbitration, well, a claimant looks within the contract and the applicable law to enforce its rights and to compel performance of the other side's obligations. But that said, they can consider, as Takatori Sensei says, using the ARB-med-ARB protocol, which is offered by the SIAC, by which they could have the best of both worlds of international arbitration and mediation.
So Quay, being based in Vietnam, I imagine you've seen a lot of enforcement of arbitral awards or perhaps mediated settlements involving Vietnamese companies or Vietnamese counterparties. Can you share any comments about enforcement in Vietnam?
So for Vietnam, the foreign court of arbitration award is not automatically be acknowledged and enforceable, but it needs to go through a procedures for doing that. So for Japan, we currently can have the legal basis for the enforcement of the arbitration award from Japan. But then for the court judgment, because Vietnam and Japan has not signed the judicial supporting agreement, so that would be mainly based on the consider of the Vietnamese government here and the Vietnamese court on the principle of reciprocity basis. And it means that not all of the cases that the Japan court award will be automatically recognized and enforceable in Vietnam.
Looking at international dispute resolution like arbitration and mediation, how can procedures be tailor-made or crafted to address cultural differences?
We have now available of the joint protocol mediation system under the COVID-19 online joint protocol between the SIMC and JIMC, the Japan International Mediation Center in Kyoto, which quite works for those cross-culture different type of dispute resolution. And the first case was actually between the Indian company and the Japanese corporations regarding the joint venture type of investment-related disputes. And I was appointed as the co-mediator with the Greg Vijayendran. So we were taking a role as the co-mediator as a one unit for taking care of the from both sides, from the common law side and the Japanese law side, and native language English side and Japanese language side. although we were not a translator or interpreter of the or messenger of their parties, but still we were co-working for the finding the commercial objects and a common interest between the parties. And parties has a sort of a different negotiation style from the cultural difference or something. So that's a really nice system as a part of the ARB-Med-ARB of the SIAC and the SIMC's combination.
So we're going to have to bring this discussion to a close. I'd like to thank Yoshi, Quay, and Natalie for these practical tips that will surely help Japanese companies investing in ASEAN. It has been a very insightful discussion. And I encourage our viewers to check out the other episodes in this series for more insights into doing business in ASEAN. Thank you.